Your neighbour stacks thousands of litres of water in a reservoir. It bursts, floods your land. Are they liable even if they did nothing wrong? Welcome to the world of land torts, where strict liability can buy even the most careful defendant. Today we're covering 3 closely related torts that all concern interference with land: private nuisance, public nuisance, and the rule in Rylands v. Fletcher. Each covers a different type of harm, a different claimant, and sometimes a different standard of liability. By the end, you'll be able to distinguish all 3 and apply them to a problem question. Private nuisance is the workhorse of land torts. It protects a person's use and enjoyment of their land from indirect interference caused by a neighbour. The key word is indirect. Direct physical entry is trespass. Nuisance is the spillover, the noise, the smell, the vibration, the encroaching roots. The court asks whether the interference is unreasonable in all the circumstances. That's a balancing exercise. Courts look at the nature of the locality. Industrial areas tolerate more than residential ones. The duration and frequency of the interference, whether the claimant is abnormally sensitive, and whether the defendant is acting out of malice. A one-off event can count if it's a consequence of a continuing state of affairs. The claimant must show actual damage or substantial interference with amenity. Public nuisance is a different beast. It's primarily a crime, historically prosecuted by the Crown, but it can also found a civil claim in tort. The interference must affect a class of the public, not just one person or a handful of neighbours. The civil claimant must show they suffered special damage over and above the general inconvenience suffered by the public at large. A classic example is obstructing the highway in a way that causes a particular trader to lose business that others passing by do not. The distinction from private nuisance matters. Public nuisance doesn't require the claimant to have any interest in land. This brings us to a sharp question. Who actually has standing to sue in private nuisance? The House of Lords answered this definitively in Hunter v. Canary Wharf, 1997. The defendants built the Canary Wharf Tower, which interfered with television reception for residents in the area. The court held that only persons with a legal interest in the affected land, owners, tenants with exclusive possession, could sue. A family member living in the property as a licensee or a spouse without a property right could not bring a claim. This was a controversial but clear ruling. Private nuisance protects land, not persons. There are several important defences. First, prescription. If a defendant has openly and continuously committed the nuisance for 20 years, they may acquire a right to do so, in the same way an easement can be acquired by long use. Second, statutory authority. If a statute authorises the activity that inevitably causes the nuisance, that is a complete defence. Third, and this trips students up, coming to the nuisance is not a defence. In Sturgis v. Bridgman, 1879, a confectioner had used noisy machinery for years before a doctor built a consulting room next door. The court held the confectioner was still liable once the nuisance was established. The doctor's arrival didn't strip him of his rights. Finally, planning permission does not authorize a nuisance in private law, though it can be relevant to the character of the locality. Now to Rylands v. Fletcher, decided in 1868. The defendant employed contractors to build a reservoir on his land. The contractors negligently failed to block some old mine shafts. When the reservoir was filled, water escaped through the shafts and flooded the claimant's mine. The House of Lords confirmed a rule of strict liability. The defendant was liable even though he personally had not been negligent. The rule, as stated by Blackburn J. and confirmed on appeal, is this: a person who for their own purposes brings onto their land and collects and keeps there anything likely to do mischief if it escapes, must keep it at their peril, and if they fail to do so, they are prima facie answerable for all the damage which is the natural consequence of its escape. 2 further requirements have been added. The use of land must be non-natural, that is, some special use bringing with it increased danger beyond ordinary use, and, confirmed in Cambridge Water Co. v. Eastern Counties Leather 1994 by the House of Lords, the type of damage must have been reasonably foreseeable at the time of collection, even though the tort is otherwise strict. In Cambridge water, chemicals used in a tannery seeped through the ground over many years and contaminated a borehole. The House of Lords held that the type of damage, contamination of an underground water supply, was not foreseeable on the facts when the operations began, and so the claim under Rylands failed. Rylands v. Fletcher has a narrower set of defences than nuisance. The defendant will escape liability if the escape was caused by the act of a stranger over whom they had no control, by an act of God, an event of extraordinary natural severity that could not reasonably have been anticipated, or by the claimant's own fault. Consent or common benefit can also defeat the claim. The most important limiting principle, beyond the defences, came in Red v. J. Lyons and Co. 1947. The House of Lords held that there is no liability under Rylands where there has been no escape from the defendant's land. An explosion occurred inside a munitions factory, injuring workers on the premises. Because nothing escaped onto neighbouring land, the rule simply did not apply. So escape is an absolute threshold requirement. Time for a check. Amara stores large quantities of industrial chemicals on her farm. They seep through the ground and contaminate Ben's well on the adjoining land. Which tort is most directly applicable? Option A, private nuisance only. Option B, public nuisance. Option C, Rylands v. Fletcher. Option D, trespass to land. The answer is C, Rylands v. Fletcher. Amara brought a dangerous thing onto her land for a non-natural use. It escaped onto Ben's land, and contamination of a water supply was recognised as a foreseeable type of damage in Cambridge water. Private nuisance might overlap, but Rylands is the most precise fit. So, private nuisance protects those with a legal interest in land from unreasonable indirect interference. Public nuisance protects the public and gives a civil action to anyone with special damage, and Rylands v. Fletcher imposes strict liability, where a dangerous thing escapes from a non-natural use of land and causes foreseeable damage. Your modules, mapped to your uni, explainer videos for every topic, a tutor that knows your course, essay writer for your essays and graded, case briefs, flashcards, annotations. Try it free for 7 days, link in the description.